Welcome back to It's Your Law. I'm George Curtis. My guest is Peter Culp of the Dempsey firm, and we know Jim Williamson's going to be watching how you do on this show, so you've got to do a good job, Peter.
Thanks, George.
You folks over at the Dempsey firm do employment law, and I ask you off camera, do you just do that for employers, or do you do it for employees? And your answer was both.
Yes.
Tell us what that entails.
There's a variety of different employment claims that can be filed. It can be discrimination claims based on race, age, gender, national origin, or it can be arrest record or conviction record discrimination claims.
And so we have a situation where somebody has a job and they work for a long time. They think they're doing a good job from their point of view, at least, for the employer. And sometimes things change. I've noticed in recent history here around Oshkosh, some of our work has been transported out of the country. Some of our companies have been sold to companies outside the area, and they downsized in Oshkosh. Sometimes a family business becomes a corporate business, and strangers come in to run it. And sometimes they bring their own in-laws in to take their place. A lot of things can happen. And what rights does an employee have?
Well, in Wisconsin, it's actually pro-employer to begin with, because usually employees are employed at will. And what that means is the employer is free to get rid of an employee at any time, or an employee is free to leave and go on to other jobs for any reason at any time. And in that case, there's really very little rights that employees have. The rights that they do have is when employers consider factors that are prohibited by law. For example, if somebody has a arrest record and that's being considered by an employer, or if somebody is of a particular gender or race, and that is a factor that's considered, and whatever adverse employment decision that is made, that's when employers can run afoul of the law.
Well, what redress is there for the employee if the employee says, for example, I was picked up for shoplifting, I really didn't do it, couldn't afford a lawyer to fight it, and now I've been fired because my employer doesn't want a shoplifter around?
The redress that employees have is they can file a complaint with the Equal Rights Division of the Wisconsin Department of Workforce Development. And it's a discrimination complaint that is filed. And what happens is it gets duly filed with the Equal Employment Opportunity Commission on the federal level, and the investigation starts by an investigating officer of the division.
What legal effect does that investigation have?
What it does is it determines probable cause to believe whether there's a violation of the Wisconsin Fair Employment Act. And on an arrest record case, the only thing that an employer can do is suspend an individual pending the outcome of the case, unless it's called the Olander rule, which says that if there is a substantial relationship between the circumstances of the crime and the circumstances and responsibilities of the job, then the employer may have the right to do more than just suspend an employee.
Well, let's say in that shoplifting situation, it gets pended a few times and gets moved from the city attorney's office to the DA's office, as that game is sometimes played. And eventually, 8 months later, my employee is found not guilty. Does that have an impact on me for having fired him or her?
It may. It may. What an employer must do in that situation is look into the circumstances of the offense. And even though somebody has been found not guilty of that offense, it doesn't necessarily mean an employer cannot suspend or terminate the individual employee, but it really requires a fact-intensive investigation by the employer.
And after the criminal or quasi-criminal authorities finish their 9-month game, I suppose this process that started out with a state agency that you described doing an investigation as to whether there's probable cause, that gets into litigation. It might be 2 years down the line and I found out as an employer I made a mistake, I terminated somebody that I lawfully could not terminate. Do they owe them 2 years' wages?
Generally, yes, the remedies available to an employee are back pay, which is the amount of pay he or she would have received from the time of the hearing back to the time the decision was made to fire the individual. Reinstatement back into the position, or front pay in lieu of reinstatement. The employer is also responsible for the reasonable attorney's fees and the costs that were involved during the pendency of that process. So it can be quite costly for employers.
All right, so employees do have some rights, which I'm glad to hear, frankly. It's traditionally been rather one-sided in the other direction in the state of Wisconsin. If the employee will stick with the fight and they're right, they may well not only get their job back, but they'll get all of the expenses and losses they've had. Of course, in the meantime, they've had to find another way to feed their family.
It is oftentimes challenging for the employee during that process because they really don't have any wages coming in to put food on the table or to continue to pay the electrical bills or the mortgage. So it's often tough. But those that stick it out and those that have valid claims are rewarded in the end.
But you indicated that there are some reasons that cannot be used to terminate people. Some areas are constitutionally protected. For example, race, religion. Is age one of them?
Age is one of them as well. Anybody who is over 40 years of age is called within a protected class, meaning that the Wisconsin Fair Employment Act protects those individuals from any adverse employment action that is based or considered on age.
Of course, that's a little hard to prove in the case of race, religion, or sex, but age is something that even I could prove.
Or me too, George.
Well, Peter, let's take our second break, and when we come back, I want you to give some advice to employers. Well, there you have a view from another law firm and another fine lawyer. Those of you who follow this show recognize that I'm rather proud of being a lawyer. And I'm very troubled very often whenever there are surveys that the legal profession kind of takes a back seat to the medical profession, the ministry, and some other areas of professionals in terms of public image. I'm troubled because I don't think it's realistic. I don't think it's fair. I think it's a misunderstanding of what lawyers do. People get into the law because they're high-minded, well-qualified. It's intellectually very competitive to get into law school because they want to do something with their lives beyond making a living. They want to make a difference, and often that difference requires taking an unpopular side of an unpopular cause. And I think the public sometimes confuses the client with the lawyer. Get to know your lawyer. I think you'll find that she or he are really quality people who are there to help you, and they're in this profession for the right reasons. Give them a chance. That's my opinion. I'm George Curtis.